It starts with a handshake and ends in a lawsuit. One minute you're building a company together, the next you're served with a demand letter from someone you once called a partner. If you're a Florida business owner, here's the hard truth. The most dangerous threats to your company rarely come from competitors. They come from inside the house. When a shareholder turns against you, you need more than just legal advice. You need a battle plan. I'm Santiago Cueto, a board-certified international business lawyer and best-selling author based right here in Florida. I've helped companies across the globe survive shareholder disputes, and today, I'm going to show you exactly what to do when a shareholder in your Florida corporation or LLC turns hostile. Let's dive in. Step 1, don't react, strategize. When a shareholder turns on you, the first instinct is usually emotional, anger, betrayal, or even fear. But emotional reactions can cost you leverage. Take a breath. Before you respond to any threats or accusations, gather information. Has the shareholder made formal claims? Are they trying to freeze accounts, access confidential data, or undermine deals? Your silence is often your greatest weapon in the early stage of the dispute. Let your lawyer respond, not your ego. Step 2, review your operating or shareholder agreement. Your next move is to pull out the governing agreement. If you don't have one, your case just got a lot more complicated, but not impossible. In Florida, shareholder rights and duties are governed either by that agreement or by default statutory rules. Key clauses to look for: the buy-sell provision. Do you have the right to buy them out? The voting rights provision. Can they block decisions or remove officers? Exit terms. Can you force a sale or redemption of their shares? If you were protective when drafting the agreement, this is where it pays off. Step 3, secure the business. A rogue shareholder can wreak havoc, especially if they still have access to bank accounts, contracts, vendors, or client data. Move quickly to change passwords, restrict access to sensitive files, notify your team, check if the person still holds a board position or officer role, and remove them if permitted. In Florida, majority shareholders or controlling managers may have the authority to do this, but only if it's in line with the company's governing documents. Step 4, document everything. Start a paper trail. Every communication with the shareholder should be in writing. Every internal step you take, such as restricting access or convening a board meeting, should be logged. Why? Because if this turns into a lawsuit, and it often does, a judge is going to want to see these 2 things. Number 1, that you acted reasonably. And number 2, that you acted in the best interest of the company. This is especially important if the shareholder accuses you of breach of fiduciary duty, one of the most common claims in Florida shareholder litigation. Step 5, consider filing for judicial dissolution or a buyout. Florida law offers tools to remove toxic shareholders if used correctly. If a minority shareholder is harming the company, you may have grounds to file for judicial dissolution, seek a court-ordered buyout, or remove them through derivative claims or under the Florida Revived LLC Act. But if you have to be strategic, filing prematurely or without cause can backfire. That's where experienced legal counsel is critical, because these tools can either save your company or tear it apart. Step number 6, protect the brand, protect the books. Don't forget the damage a hostile shareholder can do outside the boardroom. They might post defamatory content online, leak financials, or poach clients or employees. Use cease and desist letters, and if necessary, injunctions to stop reputational harms in its tracks. Florida law allows swift emergency injunctions if business interests are at risk. And yes, if they're stealing customers or violating non-competes, you can sue. Step 7, start thinking about an exit strategy. Not all wars need to end in court. Mediation or buyout negotiations might be faster, cheaper, and more private than litigation. Many times, it's in your best interest to pay the shareholder just to go away, especially if litigation would tie up the company for years. But do it smartly. Tie the buyout to release of all claims, impose a non-disparagement clause, and include a non-compete and confidentiality agreement. You're not just buying them out, you're buying peace of mind. A shareholder dispute is one of the most destabilizing threats a Florida business owner can face, but it doesn't have to destroy your company. With the right plan, the right counsel, and a cool head, you can turn even the ugliest conflicts into a win. So if you're facing a shareholder turned saboteur, remember this: you're not alone, you're not powerless, and you're not finished. Like this video if you found it helpful, subscribe for more real-world legal strategies, and drop a comment below if you've ever had to deal with a rogue shareholder or want help crafting an airtight shareholder agreement before one turns hostile.